Guys, oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll hear argument in 4 cases this morning. The first is 240892, the Attorney General against PFLAG, a direct appeal from Travis County. The second case is 2308, get this right, 0953, Ortiz versus Nelapatla from Collin County and the 5th Court of Appeals. The third case is 240053, Morrison versus Morrison from Wood County and the 12th Court of Appeals. And finally, 240245, In re Zaidi, a mandamus petition from Harris County and the 14th Court of Appeals. The court has allotted 20 minutes to each side in each of the cases. We'll take a short break between the arguments, which can be viewed online and will be available to view on the court's website later today. We're ready for argument in 240892, the Attorney General versus PFLAG.
May it please the court, Mr. Peterson will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you. Mr. Chief Justice, and may it please the court. The legislature empowered the Consumer Protection Division to serve civil investigative demands on any person the division believes may be in possession of documents relevant to the subject matter of an investigation of a possible violation of the Deceptive Trade Practices
Let me
Act.
just kind of get to a basic question that I have here, and that is that, you know, it seems that really the crux of your problem is that this has just taken so long. This should be a quick procedure. We should just deal with this, get this information just like any other type of discovery and get down the road. That didn't happen here, you know. And so aren't you asking for an advisory opinion here?
No, Your Honor, I don't believe so, for 2 reasons.
Okay.
First, because we see a link between the trial court's erroneous procedures and the trial court's substantive ruling. So by holding a bench trial on the merits, a bench trial that occurred without the benefit of discovery, we think that misled the trial court into misunderstanding its role. The trial court took the testimony of Mr. Bond, credited his explanation of the affidavit, and then in light of the trial court's findings about what I would call the probable results of the investigation, reviewed the requests made by the Consumer Protection Division. I was thinking of the appropriate analogy to a general commercial case. It's almost as though in a product liability suit, the court would, before ruling on whether the plaintiff could take discovery of the defendant's design documents, hear from the defense.
But what do you really want to happen here? It just seems that what you're wanting to happen, though, is just going to prolong this more, right?
Well, what we're hoping for from this court is a judgment rendering an order enforcing the revised CID. It may be proper for this court to modify the original CID
To your analogy about a products liability case, it seems as though we're here on a motion to compel. And so ordinarily, you know, the trial court will hear everybody on a motion to compel, ask them to narrow their categories, which as I understand you did in some circumstances. But here the trial court has ordered some documents produced. And so kind of behind the rhetoric of the parties, what documents are you seeking, that categories of documents are you seeking that they have not produced?
So it would be helpful to look at the revised civil investigative demand, which you'll find on clerk's record pages 150.
Right, I understand
yeah,
that,
okay,
but we're way far beyond that. And so I'm just asking for, you know, specific documents, specific categories of documents that would inform an order.
Certainly.
On a motion to compel, using the analogy that you presented.
Yes, Your Honor. So the first category of documents, we're looking for documents and communications that form the basis for Mr. Bond's personal knowledge of what he testified to in paragraphs 7 and 13 of the affidavit that he submitted in the Lowe case. The trial court did not order any sort of production of those materials.
And what do you mean by that? What does that specifically mean?
Well, specifically, Mr. Bond's affidavit stated, and the key sentence we're looking at is a sentence that says, PFLAG families with transgender and non-binary adolescents shared their contingency plans. Those with resources to move or seek care out of state have begun firming up their plans to do so, while the vast majority of those without resources have been asking chapters for alternative avenues to maintain care in
So
Texas.
in connection with that request, I'm assuming you're asking for documents that are not privileged, because obviously the preparation of an affidavit often involves attorney-client communication.
Absolutely,
Okay,
there's no
so what's
question.
next?
Second, we are looking for those communications that Mr. Bond referred to in his affidavit. We're looking for communications referencing contingency plans or alternative avenues to maintain care. Now, the trial court ordered some production there, but what the trial court did was limit it to, as best we can tell, a self-selected set of documents by PFLAG, not all communications, but documents showing what was meant by those phrases. Now keep in mind, the trial court has already credited Mr. Bond's testimony about what he meant by those phrases. So
Okay, let's just get the list out and
understood.
then we can continue.
So third category, recommendations, referrals, or lists of medical practitioners that PFLAG provided. The trial court limited that to lists for reasons that are not clear to us. In particular, for example, if there were a document where a family communicated with PFLAG and said, we are looking for a gender-affirming practitioner who will continue to provide this sort of care
So
after the
not
effective
just
date.
lists, but other kinds of communications.
That's right.
Okay,
Any
next.
sort of recommendation. Next is any communication, next is documents that include the factual basis for Mr. Bond's affidavit with references to PFLAG families asking about alternative avenues to maintain
Okay,
care.
that sounds like one, they're similar to one.
Very similar,
Okay, next.
slightly broader. Next, communications regarding particular listed entities. Mr. Bond testified that those communications don't exist to the extent of his personal knowledge. We're
So
asking
they've
for-
answered that there aren't communications.
Well, not quite. Mr. Bond said he's not personally aware of communications. He did not say PFLAG does not have those
Okay.
documents. So those are the main categories of
Right.
documents that we're looking for here. And I apologize for the lack of clarity. And those documents, if they existed, and if they truly did refer to contingency plans of alternative avenues to maintain care in Texas after the effective date of SB 14, would be highly relevant to the investigation that's being conducted by the Consumer Protection Division into doctors misrepresenting the treatment that's being made. To return to the question about the link between the substantive errors and the procedural errors, we think there's also a procedural error that has resulted in the permanent injunction, which allows these procedures to be in front of you as well. As we view petitions to set aside, modify, and enforce civil investigative demands, they're in ancillary proceedings, much like Rule 202 proceedings, much like non-parties' objections to subpoenas under Rule 176.6. They're not a general grant of jurisdiction for a trial court to resolve any and all disputes between the parties. In the same way you wouldn't pair a Rule 202 petition with a substantive claim, you wouldn't file a petition to set aside a CID and at the same time receive a permanent injunction along with it. So we do believe the procedures applied here are in front of this court because of the link between those procedural errors and the substantive errors. I talked about crediting Mr. Bond's testimony. I do think that's one of the key errors here, that the trial court forecast what it believed the result of the investigation would be, and that's exactly what the Supreme Court of the United States rejected in United States versus Powell. The Supreme Court has discussed similar provisions of federal law. Unfortunately, the legislature has not given us much guidance here for petitions to set aside CIDs. It has told us good cause, but the DTPA does allow us to look to relevant and pertinent decisions from courts in other jurisdictions. We have a fairly well-developed body of federal law regarding the enforcement of administrative subpoenas, and the Supreme Court has told us that the power of an agency using administrative subpoena is an inquisitorial power, essentially akin to that of a grand jury, not tied to the judicial function, and that it's actually inappropriate to take the instincts about the judicial limitations on discovery and apply them when enforcing an administrative subpoena. I'd point you to the United States Supreme Court's decision in Morton Salt. What the federal courts have held is that you must satisfy statutory requirements and judicially created standards for the enforcement of administrative subpoenas. The statutory requirements here, there are 4. 3 of them are not in dispute, that it identify the documents with reasonable specificity, identify the return date, and identify the person responsible for inspecting the copies. Those are undisputed. The 4th is a requirement that the CID state the state statute and section under which the alleged violation is being investigated and the general subject matter. Here, both the original and the revised CID stated that the statute and section are DTPA section 17.46, and as far as the general subject matter, the CID explained that it concerned potential misrepresentations.
So is there no statutory guidance available to us about timeliness, like the timeline on which one of these proceedings should unfold? And is there?
No, Your Honor.
Okay, so what should we look to? I mean, it seems on the one hand that you're saying, well, this shouldn't have taken so long, so it already has taken this long, so why wouldn't it, what should be the test or, in your view, the standard for what an opinion of ours could say if we indeed think this should not have dragged on in the way that it did?
Well, what I would urge you to hold is that a petition to set aside or modify a CID is a discovery request and objection, and it should be handled like any other discovery request and objection under Texas law. So the same as objections under Rule 176.6, the same as ordinary objections to discovery under Rule 193.
Like you get a privilege log in the same way that you would in regular civil discovery, regular
Absolutely. And
civil litigation?
If you look at the CID here, it specifically stated, both in the original and the revised CID, that PFLAG was free to create a privileged log, that the Office of the Attorney General was not seeking privileged information.
And there's never been one here?
No, there has never been one, and that is puzzling. The trial court found here that these were harassing to the extent they sought privileged information. But they
Okay,
have
but
never
back to timing, though.
Yes.
What about timing?
And I think the best you can say
In civil
is,
litigation, discovery disputes take forever, too. So,
well, they can, but they're resolved at a single hearing. And I think there's no need for a temporary restraining order. There's no need for a temporary injunction. You certainly wouldn't hold.
They're not always resolved in a single hearing.
not a single hearing, but they're resolved at a hearing by the trial court without the formality of going through the full process of civil litigation. The parties here briefed summary judgment. You would never brief summary judgment in response to a Rule 202 discovery request. So we think the best this court can do is to tell the trial courts, these are not proceedings that initiate the traditional trial process. These are just discovery objections that you should handle like any other discovery objection and attempt to resolve expeditiously. I don't see any basis for this court to.
But in answer to Justice Huddle's inquiry, I mean, it's not just like that. And many of us were trial judges. Those things go on forever.
I think that's right that they can go on, but the substantive standards here should help them be adjudicated quickly, because the general substantive standard here, at least if we look to federal law, is a very heavy thumb on the scales.
So what's your authority for that? Because I understood you to say the authority was Texas Rules of Civil Procedure having to do with discovery in civil cases, and now you seem to be wandering from that.
Well, I think we follow the Texas Rules of Civil Procedure, and generally by analogy to the Texas Rules of Civil Procedure. The Texas rules simply don't contemplate trials, bench trials on the merits, to resolve discovery disputes.
Your point is that injunctive relief is not the relief that is typically associated with a dispute over production of documents and communications.
Yes, Your Honor. Now, in terms of the substantive standard for what good cause means under Texas law, we think it would be appropriate to look to federal law. We cited, for example, the Sixth Circuit's decision in United States versus Markwood. The question is, has there been compliance with the statutory standards for the administrative subpoena or civil investigative demand, and has there been compliance with the judicially created standards? And what the federal courts have recognized
For purposes of the argument you're making right now, does it matter that the ostensible purpose of the inquiry here is investigation of a DTPA claim, which is a civil cause of action, as opposed to at the federal level you might have some broader conception of, regulatory oversight by the, SEC over some company or bank or?
I don't believe so, Your Honor. The cases that we are looking at involve similar types of claims. The CFPB, for example, the EEOC, there are federal false claims, civil investigative demands. All of these are treated as administrative subpoenas. So we think this is fairly closely analogous. The CFPB, for example, needs to be investigating a particular violation of the law when it issues civil investigative demands in the same way that the Consumer Protection Division would here. So we do think that's the right standard to look to.
Can you think of an example of something that you would argue should be allowed in terms of a CID? Some documents that would have to be turned over in response to a CID that would not in civil litigation about the claim that the CID is contemplating?
Off the top of my head, no, Your Honor, but it's difficult because obviously in discovery in a civil suit, you're looking at a particular claim, and the question you're asking for in discovery of that claim is whether the discovery is reasonably calculated to lead to admissible evidence. So civil discovery by a court is always in the context of a particular claim in a particular trial, and it's weighed against other evidence in the case. A civil investigative demand just isn't in the context of a particular claim that's being asserted against a particular party. It's much like a grand jury that's attempting to investigate, has there been any wrongdoing committed?
Is there a practice of giving a certain amount of time for the respondent to respond? Because under the rules of civil procedure, the default is 30 days, right? Unless a trial court says you can have expedited discovery or something like that. How much time does the OAG typically give someone to respond to a CID?
I don't have the typical time. I believe the petition to set aside does need to be filed within 20 days. I'll say the ordinary process here is give and take and negotiations between the parties. I point you to Clerk's Record 93 here, where you see the Civil Protection Division attempting to engage in that sort of negotiation with PFLAG. PFLAG raised its First Amendment concerns. It said, it looks as though you are attempting to seek our membership information. The Office of the Attorney General immediately said, oh, you've raised these concerns.
Is there a minimum amount of time you would concede should be allowed for someone to respond to a CID?
A bare minimum of 20 days, I believe, is what the statute provides, but let me check on that. This is not an attempt to require immediate compliance. There's certainly a right for pre-compliance judicial review.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Pollard will present argument for the respondent.
Mr. Chief Justice, and may it please the court. There are 4 reasons this court should affirm the trial court's judgment, and I would like to very briefly identify 2 issues that were first raised in appellant's reply that we haven't had a chance to address in briefing. The first reason this court should affirm the trial court's judgment is compliance. The demands are based on an affidavit PFLAG's CEO submitted in support of PFLAG's standing to challenge SB 14. From the outset, PFLAG has sought to work with the OAG's office to determine how to comply and availed itself of the process set forth in the DTPA.
Have you provided a privilege log listing out various communications and noting that you raise attorney-client privilege, First Amendment privilege, associational privilege, some other sort of specific objection to production?
We made many objections to production. We have not produced
right.
a privilege.
But obviously, ordinarily, those sorts of objections are evaluated in the context of a privilege log.
Absolutely. We have not produced a privilege log. We produced documents following the court's order that said what PFLAG was to produce. Before we had even produced documents, the Attorney General filed this appeal. The court had already set a second hearing, and based on the discussions at trial, the idea was for them to identify at that second hearing if they had any ongoing concerns about the document production. That never took place. But
have you seen injunctive relief as the kind of relief afforded in response to objections to objections to production of documents? I envision in other civil cases people trying to obtain injunctive relief against the other side, and that would, of course, escalate discovery disputes into a whole nother realm.
right. So certainly protective orders, which are not completely separate from injunctions, but the reason that the injunction...
Well, no, they're very different than injunctions, right?
That is the closest that I can think of, Your Honor, but this is a different case where the Attorney General's office had taken the position in other litigation that just seeking judicial review of a demand was a basis to revoke an organization's ability to operate in Texas. And so PFLAG was concerned that they would do so here. They expressly said in the Seattle Children's case that even if the court sustained Seattle Children's concerns, that failure to produce documents in response to the demand was a sufficient basis to revoke that organization's ability to do business in Texas. And indeed, that organization has ceased doing business in Texas because of it. So that was our specific concern that we were
Because of it, the Attorney General revoked something or ordered something, or is it just a decision?
They reached a resolution, and what's reflected in the record in their trial is that they agreed to stop doing business in order to cease the litigation. And so that was PFLAG's concern and why we wanted an injunction. The injunction is in fact much narrower than represented by appellants. It is also not properly before the court. The injunction was entered pursuant to the Uniform Declaratory Judgment Act. That's not one of the issues that appellants have challenged. But I do note that the scope is much narrower than they would represent. And appellants, despite having had many opportunities to do so and getting much closer just now, still have not identified any information that they're seeking on remand and explained how the court's failure to order the production of that information was an abuse of discretion. The second reason this court should affirm is procedure. Appellants asked this court to create a brand new...
As to what you just said, I mean, their position seems to be, there's a reference in the affidavit to the idea that there might be attempts after the law goes into effect to get around it or circumvent it or do other things. And they want to know whether there are documents reflecting those sorts of plans. And have you indicated whether or not there are documents reflecting those sort of plans? Sort of going to the privilege log question.
Yes, Your Honor. So at trial, the PFLAG CEO, the affiant, testified that that statement, which was made in connection with the lawsuit to challenge SB 14, related to the time period at which the affidavit was made, when care was still legal in Texas. And indeed, one of the contingency plans, or one of the ways that care might have been maintained, was an attempt to keep the law from going into effect, which was exactly that litigation. He testified in the lower court that he was not referencing any care that would be provided after SB 14 went into effect. He also testified that he was unaware of any doctors who were continuing to provide care. He testified that that he had never had any discussions with anyone about medical billing codes that someone might use to provide gender-affirming care prior to this litigation.
That doesn't seem like a statement that there are no responsive documents, though.
No, because the requests are much broader. The requests are for all documents relating, like communications relating to the affidavit. So there are, of course, responsive documents, documents about his communications with his attorneys preparing his affidavit. There are other requests that are broad enough that there would be responsive, in the context of discovery, responsive documents, not necessarily documents related to the investigation. And that's what the trial court found, was that the requests beyond what she ordered PFLAG to produce were irrelevant to the investigation. And that was not an abuse of discretion.
How would she know if she hasn't seen the documents?
Well, if you look at the relief that she actually granted, the evidence in front of her, there is, even under the federal standard advocated by appellants, they have the initial burden to establish a low threshold, to establish a prima facie case that there is an ongoing investigation. The investigation is within the scope of their authority, and the information sought is related to that investigation. They put no evidence in the record about those things. They, in fact, refused to do so, to the point the trial court warned them, you can stand on the objections you're asserting here, but know that that's impacting your record, and I may have to decide on the record. So the evidence before the trial court is what we've discussed about Mr. Bond's testimony, and that their investigator did not know who PFLAG was, had never seen the affidavit, did not know what SB 14 was, and they never even established that there's another investigation into gender-affirming care ongoing to which these documents could relate. And on that record, it would not have been an abuse of discretion for the trial court to deny production altogether.
But ordinarily, when someone brings a DTPA claim, there isn't a required showing as to the merit of that claim before seeking discovery.
As to the merit of the claim, absolutely not.
Right.
So PFLAG
So I'm trying to understand your point about the AG's need to bring forward evidence in support of their claim prior to seeking discovery.
Yeah, so the investigation here, they're purporting to be investigating whether providers are violating the DTPA
Right.
by providing gender-affirming care and using billing codes that they think don't accurately represent that care. PFLAG's a third party. It's always been very clear that PFLAG is not suspected of wrongdoing. The evidence that they're meant to bring is of the existence of an investigation and the subject matter of that investigation, just to show that that's within the scope. So,
And they didn't allege that?
no, it's not in their CID. They've alleged it in argument, but it's not in on the face of their CID, and it's not in the record that was before the trial court. It's an argument.
If the Attorney General comes to court and says, I am investigating X, the court should demand evidence that that is the case? I mean,
So what you
it sounds
see
almost like a mental state. I'm investigating this or that. I mean, who's to say he's not?
we wouldn't know. So what they do in the federal context and what you see in those cases is they have a declaration, sometimes from the attorney, sometimes from the investigator. Again, it's a low bar, but there is a requirement that some amount of evidence be produced that someone says under oath, this is what we're doing. This is the investigation. This is what it relates to. And the Fifth Circuit has said, many courts have said, but the Fifth Circuit, including in CFPB v. Data Services, that the reason they have to explain on the face of the document and demonstrate.
Why isn't the existence of the lawyers in court arguing that you should send them the documents as part of the investigation itself evidence that they contemplate an investigation?
I mean, this court has distinguished between argument and evidence many times, and that's consistent across many different areas of case law. That's just different from, the arguments are different from the evidence, and the arguments need to be based on the evidence, and there was no such evidence. And in addressing the federal case law, this statute, the DTPA, is distinct from any of the federal statutes. None of the federal statutes that are addressed in the cases cited by appellants contain a good cause standard. The DTPA empowers the trial court and, in fact, requires that they set aside or modify a request for good cause shown. None of the federal cases have that. And this court has squarely rejected attempts to apply federal case law to a CID statute based on a federal statute if that federal statute doesn't also have that good cause standard. That was in State v. Lowry. This specific argument was rejected. And so while some of the protections created in those federal cases would be applicable here because they're developed based on the Fourth Amendment, like the protection that the investigation be within, for good faith, that it be consistent with the agency's mission, that low standard for the deferential standard is not applicable here where the statute is simply
Was there a
different.
finding, did the trial court make a finding that there was no good cause shown? A specific finding?
Found that there was good cause shown to modify the demands.
To modify, yes, but you seem to be saying there's a good cause defense against the production, and I'm just trying to see if the trial court found that there was no good cause.
So the DTPA says that the trial court will modify or set aside the demands for good cause shown. And the court found that PFLAG had shown good cause to modify or set aside the demands, and so that was the basis on which she modified.
But not good cause to proceed?
No, that is not where the statute specifically requires when it sets the standard for the court to modify or set aside. It's good cause. And so, but even under that lower federal standard, because appellants have not produced any evidence about their investigation, let alone the link between the information sought and their investigation, they would fail to meet that requirement as well.
But I thought you just said the trial court didn't rule on that.
I'm sorry, didn't rule on what?
Didn't rule on the fact that there wasn't the affidavit or declaration that you say there has to be to show that it's, in answer to Justice Bland's question, I thought you just said the trial court didn't have a finding on that.
I may have misunderstood the question. So the trial court did find that there was a lack of good cause. She ordered some production, which I think had she ordered none at all would not have been an abuse of discretion. And we have
Well, but
not
you
raised.
wouldn't order any production if you thought that the Attorney General hadn't made the threshold showing, right? That you just said that he didn't make.
We asked her to order whatever production she thought would be responsive, because contrary to what appellants have represented, PFLAG has tried at every stage to find a workable way to resolve these with documents that everyone could be happy. PFLAG's mission is to support families, including families with transgender children. It in no way advocates that anyone break the law. It's not aware of people breaking the law. It wants to get them the information that they need while still protecting their members' First Amendment rights. And so we asked her to look at this and to order production of what documents seemed related to the investigation. So it is a bit inconsistent, but I think that's what happened here, as she went through the requests as she would in a discovery dispute.
Well, not really, because there's a summary judgment motion in a trial.
There was a summary judgment motion.
Why is there a summary judgment motion in a discovery dispute?
An excellent question, Your Honor. We both briefed summary judgment. Appellants refused to set it and styled it as a protective motion for summary judgment. I still don't know what that is. We briefed it, we served it, but they would not consent to us setting it. They said that summary judgment was an inappropriate vehicle. So despite both sides having fully briefed it, we then had to go to trial, which is part of why we have such a long record here, is because you get both summary judgment briefing and a trial record. So we attempted many times to get that set. It was our thought that that would be a better way to resolve it. You know, the procedure.
What's your position procedurally? Is any of that appropriate, or should we just have a protective order hearing, perhaps with some evidence given, and that's it?
I think there is probably a better ideal way to resolve these things, and I think that perhaps this is an issue that could be referred to the Rules Committee to figure out, is there a Rule 202 analogous procedure that could apply to CIDs? However, we don't have that procedure yet. We don't have it in the DTPA, and we don't have it in the rules. The DTPA says that a petition has to be filed. The rules of civil procedure tell us under Rule 2 that all matters in the civil district courts are governed by the rules of procedure unless they're specially accepted. And Rule 202 is a great example where the rules say, here's a different procedure, here's something different that you can do, and outline what that is. We're very open to a different procedure. Summary judgment was the closest I could come up with in this scenario, where neither side requested discovery. We could do summary judgment motions as a matter of law, and it could get decided that way.
Well, the demand itself is a request for discovery.
Yeah, and there's
So are you saying that they should have done another separate round of discovery requests?
Absolutely not.
Yeah, no, good.
I apologize if that's what I conveyed to you, because that was.
So you're sort of in agreement that this really should follow more of a model of a civil DTPA case.
In an ideal world, there would be a quicker.
And so you are sort of in agreement that probably this ending up with a hearing on an injunction is not something that would be contemplated in a discovery dispute in a civil DTPA case.
I am in agreement that there probably exists a better way, that under the federal rules of civil procedure, there are better ways to resolve this. I cannot find one under the Texas rules of civil procedure, and the fact that we tried and the trial court tried and they tried and no one has told you yet today, court, this is the procedure we should have used. I think we did the best we could have, and I think at any rate there was no abuse of discretion by the trial judge because there was no other procedure that we could come up with. Everybody got a fair shot, and as was alluded to earlier, the remedy for too much process cannot be more process. Going back to the trial court will not fix that. But I certainly think the Rules Committee and people working on this could come up with a better plan. I don't dispute that at all.
It seems like it's all been, there seems to be a lot of simplification in terms of what's come out now on appeal and what they're really asking for, and their position is, well, we're looking for documents reflecting some sort of plan for, circumventing the law after it goes into effect. And so the simplest approach would be, okay, are there or are there not such documents? And you answer yes or no. And then if the answer is yes, well, why shouldn't you have to turn them over? And then we get into a privilege log. And it's just that that's just the way these things should go. It's not that complicated. So I guess I'm not saying why haven't they gone that way. That's all water under the bridge. But why couldn't they just go that way from here? I mean, why couldn't you just answer that question?
We could have addressed that very quickly. Had anyone taken that approach, we could have been done much quicker. The requests were much broader, and the trial record shows that PFLAG does not have any documents about evading the law, about providing care after the ban went into effect. Those do not exist. The questions here were about providers. They included provider lists. When Mr. Bond signed his affidavit, I believe was June or July. The law had gone into effect in May. The petition was filed in July or end of July, and the trial was in August to try and prevent the law from going into effect in September. Their requests went all the way back to when the law was passed, I believe, in March. And so they covered a period when care was completely legal. There are communications about gender-affirming providers or about this litigation, about his affidavit, a lot of requests that were responsive. The record is clear that there are not communications or documents or evidence of anyone evading the law. That is a simple question we could have answered quickly, but that's not the question we were asked. So the court here, to reiterate, the DPA is the statute controlling here. These requests, civil investigative demands, are all creatures of statute, and the DTPA has a good cause requirement that is distinct from any of the federal case law. And the legislature clearly directed district courts to modify or set aside CID requests for good cause, and has afforded individuals and organizations in Texas additional protections against improper searches that are not afforded under the federal standards. PFLAG's mission is to support families and families with transgender children. PFLAG was not the cause of delay in this matter. They received documents in February. There was a trial by June. Documents were produced by October. The delay since then included trying to come to this court too early before there was a final judgment. As this court has held, it may not judicially amend a statute by adding words that are not contained in the language of the statute, and instead must apply the statute as written. The legislature has struck a balance between the OAG's investigatory powers and the authority of and private organizations' ability to be free from unwarranted state investigations. There was no abuse of discretion in the trial court's application of the DTPA as written to modify the CIDs, and PFLAG has complied with the modified demands. So we ask this court to affirm.
Thank you. Any further questions? Thank you, Ms. Pollard.
Thank you.
Mr. Peterson, I believe you have 5 minutes.
Thank you. Mr. Chief Justice, let me see if I can complicate what may appear to be simple, just slightly. In a traditional civil case, in a product liability suit representing a plaintiff, I would not request that the defendant turn over design documents showing that their product is unsafe. I would ask the defendant to turn over the design documents for their product and then be able to use those documents to make my case that the product is unsafe. And that's really, I think, the crux of the dispute between the parties here. What the Consumer Protection Division is asking for is PFLAG's documents referencing these contingency plans, referencing these alternative avenues to maintain care in Texas, and referencing the gender-affirming practitioners referred to in the affidavit. If it were to request, please provide documents about contingency plans and alternative avenues to maintain care that show that you are assisting doctors violating the law, then I think we're going to hear exactly the same answer that we just heard from my friend, which is we don't have any of those because we're not assisting doctors in violating the law. So when what PFLAG is attempting to do is to limit the civil investigative demand to we will turn over documents that show we or doctors are acting wrongfully and there are none. What the Consumer Protection Division is saying is we are conducting an investigation. We read your affidavit differently than you now represent its meaning to be, and we would like to see the documents underlying that affidavit to see whether Mr. Bond's representation about what he meant is correct or not. I will say, I think there are reasons to be questioning about the interpretation of the affidavit that you've heard today. There's a suggestion that the contingency plans related only to the period in between the passage and the effective date of SB 14. I think if you look at paragraph 13 of the affidavit, which of course is an affidavit about why SB 14 shouldn't come into effect, it's more naturally read as contingency plans about what would happen if SB 14 were to come into effect. But again, the investigation that CPD is attempting to conduct is to determine what was meant by that. With respect to evidence about that investigation, I point you to clerk's record, pages 1488 to 89. That's an affidavit of Sam Weeks, who testified consistently at trial generally about the investigation being conducted by the Consumer Protection Division. If you look at page 9 of the district judge's opinion, there was judicial notice taken of 3 cases that had been filed against doctors under similar theories. And of course, the division presented the affidavit of Mr. Bonds and explained its relevance as it interprets it to the investigation that it's conducting. My friend and I read the Lowry case differently. As I understand it, it's about the ability to discover materials that have previously been acquired through civil investigative demands. It doesn't relate to enforcement of civil investigative demands. Procedurally, I agree it would be nice if the procedures were more certain here, but I will say, if you look at the rules, nothing in Rule 202 says parties may not file motions for summary judgment. Nothing in Rule 176.6 or Rule 192.6 says it is inappropriate to hold a bench trial on a non-party's objections to discovery. Instead, it's clear that they are motions regarding discovery matters. And if you look even at Rule 202's predecessor, bills of discovery, it was understood that they were resolved as motions like any other motion. And that's what we're looking for here, is simply a recognition that a petition to set aside or modify a CID is reviewed as a motion, just like any other. Critically here, nothing changed on the facts between the temporary injunction hearing in March 2024 and trial that occurred later. All of the evidence that PFLAG presented at that temporary injunction hearing was equally available to it all of the evidence that PFLAG presented at trial was equally available to it at the time of that temporary injunction hearing. And that's really the issue with the process, is setting these separate hearings when all of them should just be hearings focused on, there may be multiple hearings of course, but focused on resolving what is at its heart simply a discovery dispute. My friend asked about the protective motion for summary judgment. If you look at clerk's record, page 591, the Office of the Attorney General has consistently maintained that trials don't exist in this setting, that it should have been resolved like a motion at a hearing, and that this whole summary judgment process was improper here. One final note about the permanent injunction. There was very little discussion of this, but I'll do note that the permanent injunction permanently prevents the Office of the Attorney General from acting to revoke the charter of PFLAG and its affiliates. That threatens the Attorney General's constitutional authority under Article 4, Section 22 to seek judicial forfeiture of charters when appropriate. The permanent injunction is inappropriate here. Thank you.
Any further questions? Thank you, Mr. Peterson. Thank you to all counsel. The case is submitted and the court will take a brief recess.
All rise.